Yeah, you sit down there.
Let's just start. Jim, you're in the front. You're next to.
Okay, I'm sorry. I thought it was at 1:15. I'm sorry,
Okay, let's
guys.
go sit there. Yeah, let's go sit there.
I'd like to hold the judge in contempt of court
Sure, exactly.
for
Texting?
for failure to comply with the
Seriously.
postpone me
When I'm ready for this.
Guys, we're good.
Okay, we have a general question.
Yes,
The whole group.
yes.
Were we supposed to have a script and like cite this stuff? Or
You don't have to. I know, no, you don't have to. I
We're
know the
only
other
gonna
class,
decide this.
some of them had papers just for comfort. It's not that they were, you know.
It's not that. It's the other group. They made a thing.
Yeah.
I was like, I don't know the
Well,
question.
not one group didn't do that. Two groups sort of did. They sort of had, like, they sort of, you know. I'm not gonna agree to Okay, are we ready?
Like the goal should be to stop this mess. It's not one of us,
The purpose is to bring out the elements that you've learned, and not to, you know, stick it to one or the other, okay? No cat fights or, you know.
Well, you had enough of that this morning.
We had a little.
Yeah.
little-
You had to know that was coming
Kevin.
close to. What happened? Really? What happened?
You have to try to get
Jeez, I could have told you a while away.
I didn't know.
Try to fucking get
What
everything.
happened?
A little bit there. Good for tactics.
Try to bring up every point.
Okay, we're ready? We're ready, guys? Okay, so the court is in session. So Kevin,
Yes.
introduce yourself. You're the attorney for the plaintiff, so you'll stand and you'll introduce yourself. Then you will introduce yourself.
Good afternoon, Honorable Judge and fellow witnesses. My name is Maître Kevin Munguia, and I am the representative of the plaintiffs in this court proceeding.
Thank you.
Good afternoon. My name is Mario. I'll be defending Mr. Robert Eastman, my client, who is on accusation of latent defects concerning property sold through the Brents.
We'll begin with your first witness.
Yes, with the permission of the court, I would like to ask my first witness, Mrs. Brent, to stand, please.
Mrs. Brent, raise your right hand. You affirm to say the truth and the whole truth and nothing but the truth. Say I do. Your witness.
Before we commence, I'd like the court, with the permission of the court, to admit a deed of sale represented as Exhibit P1.
If this has been communicated to the other party,
Yes, it is.
if there's an admission, so for the purpose of the record, P1, which is the deed of sale, is admitted.
Good afternoon, Mrs. Brent. What exactly do you do for a living?
I'm an elementary school teacher.
Okay. And how long have you been married to Mr. Brent?
7 years.
So when exactly did you purchase the house in question?
On July 1st, 2011,
And how much was the property purchased for?
$320,000.
320. Okay. And what condition was the house in when you purchased it?
Same as we saw it, no apparent damages.
No apparent damages. So were you informed of any damages?
I was informed of previous damages that were apparently fixed.
Okay. And what was discovered?
I discovered water infiltration damages that were caused by a crack in the foundation.
And when did you discover these damages?
Late spring 2012.
Okay. And would you please explain to the court what did you do about the damages?
I first got an expert witness to examine the damages, and then I contacted Mr. Eastman.
Okay. And what did the owner do or say when you contacted him?
Mr. Eastman never answered any of my calls.
Okay. Now, pertaining to the damages, how has it affected your lifestyle?
I've had to empty the whole room, take out carpeting, open windows and doors to air it out, and because of the cold weather recently, I've had a lot, me and my husband have had a lot of colds.
All right, that's it. No further questions.
And would you cross-examine the witness?
Time out. We're supposed to get opening speeches.
You can.
What are we supposed to do?
You don't have to, but you can. I mean, he didn't, but it's a prerogative. You could, before you start, you can.
Even if I have to cross examine?
Yeah, you could, if you want. prepared one, you wanna say if you wish? Because you did say it's about legal.
I thought in court, I thought we do it like before the question.
Sometimes they do. The judge might say, can you just tell me what it's about and whatever, but sometimes the judge read the file so he knows it's a late and
Mr. Brent, good afternoon. Is the wall fixed?
No, I haven't fixed it yet.
We are at December 2nd, right?
Yes,
When did you discover the damage?
late spring.
So for late spring, we say April? April,
Yes,
so about 8 months of the wall's not been fixed.
that's correct.
So have you performed any mitigating damages?
No, I haven't.
Is the reason why the wall's been fixed?
I've been waiting for Mr. Eastman to answer me because I would like him to pay for the damages because they were not caused by us.
Okay. What's your family income? Your household income?
My family income is about 50,000 a year.
50,000 a year, family income. So you're telling me that, and your estimate was $48,000? So that's your entire family income?
More or less.
So is it possible to say that maybe you refuse to fix the wall because you cannot afford to pay for damages? You went to my client in order to pay for it?
Not necessarily. I don't think it is our responsibility to pay for it.
Because I mean, last week we did have snowfall and your wall is falling down. So unless you want a solarium, I would fix the wall. Don't you agree?
Yes.
All right. And you said that you were informed of the damages, of the previous damages.
Yes, but they had been fixed according to Mr.
They had been
Eastman.
fixed. So my client did reveal to you that he did have a problem. He did fix the problem.
Yes.
Okay. And he fixed the problem in front of who? He told you this in front of who?
What do you mean?
When did he tell you this? When did he reveal this information to you?
When we were discussing the house and the sale.
Okay. Was there a person in particular in the room with you besides you and your husband and Robert Eastman?
No.
No? This was not done at the time of the sale?
No, it was done previously when he was telling me about the house.
Okay. Did you receive a copy of the bill of when Robert Eastman did fix the damages 3 years ago?
Yes, he showed me.
He showed you. So you were aware that the wall did have a problem?
Yes.
That's all I need. Thank you.
Any questions about it?
No?
Thank you. Next witness?
With the permission of the court, I'd like to call my next witness, expert witness, Andrew Leclerc. Presentations.
You solemnly affirm to say the truth, nothing but the truth. Say I do. It's your witness.
Before we commence, I'd like to ask permission of the court to admit evidence under exhibits P2, P3, and P4, which it shows the damages and the expert report by our witness.
Okay. It's been communicated to you.
What's P3?
P3 is,
This was report.
yeah.
It's good. The same wall I have. The same wall I have. I believe.
Ms. Leclerc, who exactly do you work for?
RBQ, which is the Fishing and Sports and Quebec.
So that is a governmental firm, am I correct?
Yeah.
Now, what field do you specialize in?
I do home residential construction inspections.
Okay. And how many years' experience do you have?
15 years.
Okay, now what kind of damage have you seen before in your line of work?
I've seen many different things having to do with roofing problems, interior leaks, insulation repairs, just to name a few.
Okay. Now, is it apparent that there was an attempt to repair the wall?
Yes, there was.
So what did you notice about the damaged wall?
The insulation has been replaced and the drywall has been replaced in that specific area.
All right, and have you ever seen damage like what you've seen at the Brent's residence?
Yes, I have many times.
And what, in your expert opinion, have you concluded about the damages?
Well, they weren't adequately done, considering the cracks in the foundation and removing all the moisture out of the wall.
So just to reiterate, what exactly needed to be repaired and how?
Well, in my expert opinion, there's 3 essential steps that are needed to be taken when dealing with water infiltration. The first is to eliminate the damage, to take it out, which which would be assessed with a moisture meter, which would indicate the exact location of the moisture. Then you would air out the room and the furniture and carpeting, and that's crucial to do it within 24 hours. The second step is to restructure any foundation, such as cracks or wood, anything else. And the third step is the final one, which is to re-insulate it, and it's a special technique that has to be done in order to not allow more water to come through. And also you have to redo the drywall, and it must be painted with anti-bio paint. So.
Okay, so basically, what was the step that was left out?
Really, the painting of the wall did not contain that, and the way the foundation was restructured was incorrect.
Okay, and what would be the dangers if this problem wasn't corrected?
Well, on a small scale, you could have fungi that would build up and odors, but on a larger scale, it's very dangerous for your health just because it can cause irritation or allergic reactions, and on a bigger scale, because of the microbial growth, there would be serious diseases that can be developed.
Now, are you familiar with the company that was claimed to have been used in the reparations of the damages?
Yeah, Excavación Residuos Segura are well known. I mean, they're known to get the job done and do it adequately, so I've never had any issues with them.
So basically, who's at fault here for the insufficient or inadequate repairs of the damages?
The defendant, the owner of the house.
And so, just also to clarify, do you think that in eight months of the damages compared to when the damages were claimed to have been fixed would make much of a difference in the grander picture?
Not really.
So basically, what you're saying is that the negligence of the defendant and not the incompetence of the constructors were the cause for this.
Yes.
No further questions.
Your witness? Ms. Carrillo?
Ms. O'Carroll, are you familiar with my client, Robert Eastman?
No.
No?
As far as past the trial.
For the record, I'll submit it right away. Here are my client's income tax reports for 2011. Communique is D1. Comparable Canadian and
Have they already been communicated?
Yes.
It clearly states that he is a real estate agent. He's worked there for many years. Do you presume that a real estate agent can know or be knowledge if a repair to a water filtrated wall was done adequately or not?
No, I mean, it's not his
So then how is it his fault?
Well, when you're selling a house, it's usually deemed to, as from the inspector's point of view, to get the house inspected, to make sure for your own sake and for future sales.
And whose responsibility is it to get it inspected?
It can be both parties.
Both parties. So my defendant, as you're claiming, did not have the house inspected, but the Brents didn't either, is strictly my defendant's fault.
No, I'm saying that the initial, there should be an initial, in my expert opinion, there should be an initial examination that should be done by the owner of the house, just for their own sake, and then the new owners should be inspected as well.
Okay, so how is it solely my client's fault?
Sorry?
How is it only the defendant's fault that the wall was not adequately done, even though it does not have any building permit, it does not work for Residuos Segura excavations, nor yet have any expertise on putting a G-block to a wall? You just claimed that it's his fault.
Well, the repairs were not adequately done, so that's all I'm attesting to.
But you did say on record 2 minutes ago that it was his fault.
Yes, in the case where the repairs were not adequately dealt with.
But how can he judge if it adequately dealt with or not? Your house inspector, you should know how to judge it, no?
Objection. Same question 14 times, Your Honor.
Question is, she is an expert, she's testifying on her expertise of what the damage is. You're in a latent defect. It doesn't matter whether he knew or he had the ability to know. If the property has a defect, it has a defect. It doesn't matter whose fault it is, right? I mean, if there's a crack in the foundation, it doesn't mean he made the crack.
I already had my question.
Yes,
Have you met with the Brents prior to an inspection?
or for the government.
So they called you, so they contact the house.
Yeah.
They revealed to you that they were already aware that there was a repair done on the wall. They were already revealed to you that they were aware there was a repair done on the wall.
Yes.
Thank you for the question.
With the permission, again with the court, I'd like to call my next witness, Jasmine, to the stand. It's like Sha. She's Jasmine.
Solemnly affirm to say the truth and nothing but the truth. I do. Your witness.
Before we proceed with the questions, Your Honor, I'd like to ask permission of the court to submit Exhibit P5, which is the insurance claim and the check that was given to the defendant.
And that your witness, Jasmine, is?
The insurance broker
So-
who deals with.
Okay, I will accept it for the purpose of the trial. Normally, you would have to submit it via her. In other words, you would show it to her
Oh,
and then file it, because it has to be filed by the person, right? Like, I'm not gonna be extremely
Okay.
formal, but this is just a point for you, okay?
okay.
That's what I'm thinking. Okay. So she's the insurance adjuster.
Jasmine, what company do you work for?
Allstate Insurance Company.
Now, what date was the claim for this damage made?
On August 15, 2009.
Okay, so 2009, August 15th, the claims were made. Now, what was the claim for, as stated by the defendant, your client?
She claimed that damages on the foundation of the home and also the water infiltration through the house inside some of the rooms.
Okay, and what were the reasons that he claimed these damages were caused by?
It was superior force because of the weather conditions and also the age of the home.
So how much was the total amount of the damages he claimed?
16,000.
Okay, and how much did you issue the defendant?
We issued only $9,000
So why only $9,000?
because the insurance covers 50% of the property claims.
Well, 9,000 is a bit more than 50%. Is there a reason why you gave more than 50%?
Well, since the main issue is the foundation problem, which costs more than the interior repairs, we issued another $1,000 to cover the expenses.
All right, thank you. No further questions.
I'll submit as D3. You already have the check, if I believe.
Yes.
And the check. Also,
Okay.
the bill from Expresión Resort Seguro that was issued to my client,
Not contested,
which the insurance policy.
covered, paid for this bill.
Ms. Ayub,
Yes.
what's the procedure concerning insurance claims?
Or when the insurer calls and there's a problem, we check the claim and we verify if he's covered and how much percentage he's going to be covered, so he's covered 50%. And that fell under our description.
And he could just say it's $8,000 and you give him $4,000. Or
No,
is the
they-
documentation before, what else?
We have to
Objection.
validate.
She just actually stated that they verified the claim.
Okay, but he's in cross-examination, so I'm gonna allow him some time.
Review the question.
Just for the witness,
Yeah.
for the witness to.
Basically, once my client called you,
Yeah.
do you have to send you some sort of documentation regarding the amount, or could he just tell you over the phone, the damage is $5,000, my wall has water infiltration?
No, we have to send this documentation.
Send you the documentation. So you gave him 50%, which was $8,000,
Yes.
plus $1,000 for interior damage.
No. Because the foundation was a major issue, because of the age of the home, we gave $1,000 more. The interior repair cost less than the foundation.
Okay. But it does say the foundation of the home.
The foundation of the home,
It
and
does say the water damage was on the second floor.
but the foundation of the home caused problems.
Objection. She's not an expert witness as to that.
Well, it's just because the documentation had been seen by insurance company, seen the foundation when it was on the second floor.
So maybe the question is, what damages did you cover? What did the insurance cover, for what type of damage?
Well, the insurance covers property claims, so he's claiming that the foundation has an issue, and also the water infiltration due to the superior force. It was major rain and it caused damages, and it came inside the home.
Does the bill have to be given straight to you? Do you deal straight to XPSF, or do you pay my client first?
It's sent to the company, and then we evaluate it, and then we issue them a check.
Because you don't deal with my client, you deal straight with the company.
Yes.
So is there any possibility that my client could have frauded the insurance company?
I believe so.
No.
Objection. Relevance?
Well, because she's claiming there's missing money, they said. So is there any possibility?
We're not claiming that
Well,
there's missing money.
She's the insurance adjuster, so
Yeah.
she's telling you, this is what I got and this is what I paid out.
Yeah.
She doesn't know anything
We
else.
cover up to 50%.
She got a claim and she paid out according to their policy.
I didn't question that, what's the $1,000 for it?
$1,000?
Yeah.
It's because the foundation costs more to repair than the inside of the house. So we gave $1,000 more. So we issued $9,000 instead of $8,000.
It's usual procedure.
In this case, there was an exception.
Was an exception. All right.
No further witnesses, Your Honor.
You're ready to do plaintiff rest?
We're at. I want to call Jamie Lynn Secarici.
So this time, notary. Okay,
Objection, attorney should know the person's name.
Attorney Shawarji.
Now. Solemnly declare to say the truth, the whole truth, and nothing but the truth. Say I do.
I do.
Your witness?
Your Honor, P1,
Yes.
can I just show my witness?
Sure.
Mike Jamie Lynn, are you aware of what this is?
Yes.
What is it?
The deed of sale
That?
on the property in question
Between who?
between
How are you aware of it?
I drafted it.
Drafted. Okay. Thank you. So you are the residing notary that made the deed of sale between the two parties?
Yes.
Thank you. I would like to submit now the court D2. Here you go. If possible, I'd like to show my witness what it is.
Yeah.
Mike Jamie Lynn, please explain what this is and come to the court.
This is an affidavit I signed on July 1st, 2011.
Has it been communicated to the other party?
Yes, but for the reasons of the court, I'd like to state what the affidavit is about.
Can you, are you gonna question her?
You would like to speak?
No,
I'd like for her to state
Oh, okay.
for the purpose of
So
the
I would like
court.
to speak with.
I understood. So what is this affidavit?
Yeah, I'm waiting.
The point of the affidavit is that I was the notary who concluded the deed of sale between Robert Eastman and David and Mary Brent. The point of the deed of sale and that I was a witness to the transfer of the documents between Robert Eastman and the Brents.
Anything else in the affidavit?
That's what it says.
Second point?
That the deed of sale was published on April 9th.
The third point?
I witnessed the transfer of the documents.
Are you aware what documents were transferred between the two parties?
Yes.
Which were? Explain.
The deed of sale.
And?
What other one?
Objection.
That was a-
She's not an ex, she's, I guess you.
Well, no, she's asking, she signed an affidavit as to attesting the transfer of documents. So which documents is she referring to? That's what you're asking?
Yeah, what documents?
Yeah, what are the documents that you attest to the transfer?
What documents were done, deed of sale? Were transferred between two parties?
Stumped by the question, Your Honor.
Stop. Another question. No further questions, Susan. Yes, I'm at home. Yes.
You said you were the notary who resided over the purchase and the deed of sale, am I correct? You said you witnessed the documents that were being transferred between Mr. Eastman, the defendant, and my clients, the plaintiff?
Yes.
Can you tell me what was in those documents?
No.
So, you're testifying to witnessing the transfer of documents, and you don't know what it pertains to.
I work very hard. I'm always tired. You know, there's things in my files I lose track of.
No further questions, Your Honor.
And my notary keeps me very busy. I teach also. I get very.
She can go.
Thank you.
Next witness. Joseph.
It could be, for the record, she attests in her affidavit that she transferred, that there was a transfer of documents. You know, she could say, yeah, I saw them giving each other documents, maybe she's not aware.
Last week, she knew the document.
Oh, okay, well,
Bullshit.
It's okay. I'd like to now call Ms. Jessica Rossi to the stand, my expert witness.
okay. Do you solemnly say the truth and nothing but the truth, say I do. Your witness?
Open the door, not fine. Alexa, record D4.
Yes.
It's her expert witness testimony.
Yes.
Communicated?
Ms. Rossi, are you the one that drafted this document?
Yes.
Perfect. What's the document state?
It states that it was caused by water, the water infiltration was by superior force through the previous winter due to the heavy snow and due to the few ice storms that had.
Okay. Ms. Rossi, what's your expertise in this field?
My expertise in this field is I have several expertises. I'm a builder inspector. I do antique homes and modern homes. I also am an engineer and an architect, and I've also taken specific courses due to sampling paints of the wall. That's
Who do you work for? Do you own practice?
Rossi and Porcelain,
Okay. How many years have you been in business?
25 years.
Thank you. Like you said, there's water infiltration done by superior force. You stated in the document. Was there any other thing peculiar you found regarding the damaged wall?
Yes. As I took a sample of the paint, it resulted that it was 3 years old, so which proves that it has never been painted ever since the damage was occurred.
And how was this test done?
It's done to a special moisture meter that we take and we just scrape off the paint and put it, and then it comes off.
So the work that was done on the wall, what covers the sheetrock, that was 3 years old. So there has been no repair done to it since then. Presumably, maybe my client maybe hit something in the wall before sale. It has been dated about 3 years ago, roughly around the insurance claim, which I'm sure you heard about.
Yeah.
Thank you.
Ms. Rossi, what's your relation with the defendant, Mr. Eastman? None whatsoever? Okay. So, Rossi, as in the Rossi Natero, as you stated, you're the owner of this company? So you're an owner alongside with Mr. Borsellino? Okay. Now, how long have you been working together?
With Porcelain?
Yes.
25 years.
25 years together. So you guys have equal seniority. So you don't have to answer to anyone then, do you? You have the final say? Now, as a point to your inspections, did you inspect the claimed cracked wall as well, or did you just inspect the drywall inside?
Both.
Is that stated in your?
Yeah.
And was the foundation still cracked, or was it fixed?
It wasn't fixed.
It wasn't fixed. So still from the time of when it was.
Objection, Your Honor. Is it referring to the foundation 3 years ago, or the foundation?
Maybe just clarify.
Foundation now.
At her inspection,
at her
at the time of
inspection.
her inspection.
At the time of her inspection. So it's still cracked.
The exterior foundation.
Okay.
Once again, objection, Your Honor. The Brents did state prior that they did not fix the wall yet, so I don't see irrelevance into that question.
Okay, so you're just confirming the facts?
I'm just confirming facts. The fact is that the wall was never repaired initially.
That's what you said.
But that's not what she said. She said that she evaluated the damage now. She had no idea what happened.
No,
3
she
years
can
ago.
only testify what she saw when she saw it. She can't
So,
testify what's happened.
The statement that it was never repaired initially has no relevance.
What he's saying is, she wouldn't know if it was, maybe the question should be, from what you've noticed, did the wall seem to have been repaired? Understand?
So being the owner of your company, where you have the final say, where you have equal seniority with your partner, you pretty much answer to the request of the defendant and whatever he wants, am I correct? You, being the owner of your company, having no one really to answer to, that you make your own final say, you were pretty much at the request of whatever your client
When I
is.
did my job, I went in and as a professional,
Yes or no question?
I'll allow her to answer the question.
as a professional inspector, this is what I saw and this is what it is.
No further questions?
Call my client, Robert Eastman, please.
Clearly. You want to talk about the decorum of the courtroom?
Remember that?
At least my hair is not showing.
Mr. Eastman, you solemnly affirm to say the truth, nothing but the truth? Say I do?
I do. Nothing would make me happier, Your Honor.
Oh my god.
You're with us.
Oh my god.
That's what we're on.
Mr. Eastman, what's your current occupation?
I'm unemployed
Why are you?
because, I was formerly a real estate agent, and the accusations of the plaintiffs have basically ruined my reputation in the realm. I'm gonna have to rebuild from scratch.
Okay, please, D1, Your Honor.
Sure. D1?
Yes, please. His income tax return. Mr. Eastman, are these your 2011 most recent income taxes? Or does it have-
Objection. Subjective question.
Can you please tell me what those are?
It's my income tax returns, federal, provincial,
From what year?
from 2011.
Yeah, what was that?
That's right.
Your Honor, also submit D5.
Which is an unemployment record of unemployment?
Yeah.
Just to see.
Oh, yeah, sorry.
Mr. Eastman, what is this document?
This is my employment record, stating my previous work at Central Minimum.
Thank you. Here you go, Your Honor. Mr. Eastman, what was your previous salary essentially one before they laid you off?
I used to make around the good part of $150,000 a year.
Mr. Eastman, do you know the plaintiffs?
I know them through the sale, but not.
Subjective.
It's a subjective question, but unless it's the answer is contested, you can ask, maybe the question could be reformulated. What is your relationship with the
What
plaintiffs?
relation with the plaintiffs?
Well, I met them through their interest in buying my home.
The sale for your home, was it personal or business?
Well, it's personal. It was the house I lived in.
Okay. Can you please explain to the court what happened 3 years ago at your house?
Oh, well, as I'm sure you all remember, we don't get the nicest weather around here. And due to all the snow, ice storms, everything, basically caused a lot of damage. You know,
I'm going to accent to a southern accent.
Started off in the Bronx, now something's in Georgia.
Objection. He's not an expert witness,
No, but the question doesn't require an expert.
That's what happened 3 years ago, that's what.
Yes, what
but
happened?
he's making an expert statement. He's making.
well, did it not snow, Counselor?
Granted, but it doesn't mean that it has anything to do with the damages incurred.
Explain to what happened 3 years ago concerning insurance and everything.
Insurance there.
Forget the weather.
But don't, for the purpose, okay, the weather, I mean, he can make a statement that we've had an unusually cold winter, warm, I mean, he's not testifying as a meteorologist, you know, it's just
Right.
it's a manifestation.
Lots of bad weather, problems with water infiltration.
Okay. How much was the claim?
Claim was for $16,000.
How much is your good claim?
They gave me $9,000.
Once you sold the home, how long after did the Brents communicate you regarding the water damage?
Oh, it wasn't until much later after the sale. I mean, they couldn't have waited a little longer.
All right. How much are they claiming?
I believe they're claiming around $40,000.
Okay. Do you have any evidence regarding this $40,000 receipt? Or valuation or whatever it is?
No, I just straight up called.
So, I'd like to submit a D6.
What's the inspection?
Mr.
Yeah. Yeah.
Mr. Eastman, please tell me what this is.
This is the inspection I've done for the water infiltration.
By?
It was by, I believe, yeah, Rossi Porcelain, Mr. Carrasco.
Perfect. Was that the lady prior to you?
That's correct.
Thanks. Well, Mr. Eastman, Please read to the court exactly how much damage this court case has done to you.
I mean, countless of dollars lost. I mean, my reputation's ruined. In the business now, I believe I could talk with this with experience as it is my field of expertise.
How long have you been doing this field for?
Upwards of 10 years.
Excellent.
Reputation's everything. The second you get an asterisk next to your name, you're done. And let me tell you, it's not easy to bring it back.
Okay. Monetarily, how much money have you suffered? How much monetary damage have you suffered? Financial?
Well, to this point, I would say $150,000. I have lost my job. I need to start over, basically.
Okay.
That's just for 1 year.
Mr. Eastman,
Yes, counsel.
talking about your job, when was it that you lost your job?
It was a bit after the claims, if I'm not wrong.
You don't know exactly when you got fired.
I was devastated, and I mean, the date's kind of blurry. I'm sure you can imagine.
Okay. You claim that the damages 3 years ago were done from superior force, i.e. Snow, rain, heavy weather conditions.
That's
Am I
right.
correct? When was the house purchased?
Well, I have to receive the deed of when I bought it.
The house was purchased July 1st, 2011. What season is that?
July, that would be summer.
That'd be summer. When were you contacted about the damages?
I don't really recall.
You were contacted, first of all, without answer, after the winter of 2011-2012. So, if they tried contacting you with no answer, I might add, how are you to know exactly what they wanted or how much the claim was for?
Well, they did leave messages, and it is not my responsibility to go.
Objection, Your Honor. We never, as a defense, we never denied that he did not receive his demand letter, which stated the amount that he had quoted.
Fair enough. So do you not think that being purchased in the summer, that you wouldn't notice damages until maybe at least after winter and all these harsh conditions in spring?
Tell me, counsel, I don't believe.
Objection, Your Honor. What's that question? I personally don't understand it.
Well, you claim that the damage that happened to your house 3 years ago
Yeah.
were because of rain, water, snow, harsh conditions, as you so forcibly said towards me, correct?
Correct.
Objection
So-
once again. Forcibly is a rather strong word.
Well,
You might be
he
thinking
made a
that my
direct,
client-
he made a direct comment towards me as a counselor.
You might be claiming that my client took a sledgehammer to the wall.
Listen. Let's be complete. The witness said that 3 years ago there was damage due to superior force.
Yes.
Filed an insurance claim and got compensated for it.
Yes.
So your question, if I understood it correctly, is if the property was sold in July, then the problem with the water infiltration only manifested itself after the winter, correct?
Yes.
So what is the question? He said
Well,
yes.
my question is, do you not believe so? Do you not believe that you wouldn't see any damage until after the harsh conditions that we live in?
That in July, when you sold the home, there would be no damage because we were in the summer.
Not necessarily. I mean, if you're talking about damage, I think it would be very clear to see it.
Okay. So, you claim to have given the house in perfect condition, correct?
That's right. Apart from what I disclosed to the clients.
What did you disclose? You disclosed that
Oh,
there were repairs done,
That's
correct?
correct.
So then the house is technically in perfect condition.
Should be, yeah.
Alright, so what exactly did you file the claim for?
Well, to the ruining of my reputation, my livelihood has been completely.
Not that, I'm talking about the insurance claim.
Then I don't understand the question.
What did you file the insurance claim for?
To fix what needed to be done.
What exactly needed to be done?
Objection, Your Honor. We went through this about 15 minutes ago.
He didn't actually say,
You could
state
show
it.
him the exhibit, ask him the question as a witness, and then you could show him the exhibit.
I'm going to take the exhibit, P4, P5 I believe it was.
He's asking my client.
What was the repairs that he did? I mean, he
Well,
did it, right?
what
What
did-
why did he make an insurance claim?
Yes.
I just asked him that question.
Yeah, but he's in cross, so maybe he's getting something, so I'll let him
Right,
ask.
for the water infiltration.
What else does it say there? I can actually point out to you where it says it. Right. Can you please read that?
Number 4?
Yeah.
State cause of incident, give full details of how it occurred, cracked foundation and water infiltration.
So, cracked foundation and water infiltration. Did you actually pay or have the construction company fix the foundation?
Well, I pointed them to the problem, I told them to fix it, and I paid the full, so I believe it was all done.
But you claim the damages to be 16,000 and you only paid 9,000. So how is it that you're paying for it in full?
Well, I paid the price of the cost, I mean, whatever they gave me.
Objection, Your Honor, they gave him 50%, so their $7,000 came from his own pocket.
Yes, granted, but the bill, as shown here, was the construction company
It was for $9,000.
was for only $9,000. So, where's the rest of the money? Where's the rest of the $7,000? You clearly didn't pay the construction company the full amount.
Well, that's their problem, not mine, is it?
Well, you being the homeowner, you need to pay for the work that's required. Am I wrong?
That's correct, but whatever the bill they gave to me, that's up to them.
Once again, objection, Your Honor, I'd like to reiterate that we are considering latent defects in this case. My client does not deny any of the Brents that they are aware that there were the damages. Whether damage was repaired or not, my client did disclose to the Brents that he did have damage 2 years ago.
The question is,
No.
if the damage was $16,000 to repair and he collected 9, then the question is, did you have it repaired and what did it cost in all? That's the question.
Okay.
Saying, okay, the insurance gave you 9, did you disperse the other 7? Is that what your question is?
Essentially,
Or you
did you-
didn't and you just had it half fixed because that's all you got from the insurance? That's what you want to know.
But I'll restate the question, Mr. Eastman. With the $9,000 that you got from the insurance company, which covered only 50% plus the generous $1,000 that they had given you, what did you pay the construction company to fix?
Do you have the bill? Because I can't recall as it was some time ago.
I find it hard to believe that you cannot recall. What does it say on the bill?
$9,000.
And what does it say for what reparations does it say for?
It says, complete rebuild, replaster, and paint the damaged wall.
Damaged wall. Does it say anywhere in there about a foundation?
I believe the complete rebuild does cover that, yes.
If it really covered that, then wouldn't the expense be a little bit more than $9,000?
I'm no construction expert, so I couldn't tell you that.
But you are the homeowner, it's your responsibility for the damage, am I not wrong?
Right, but it's not my responsibility to build myself.
But you were aware that there was a cracked foundation.
I was aware of damages, and I was aware I paid for those damages to be fixed.
And in the description of what was done, is there anywhere saying that it was a cracked foundation that was being repaired?
Once again, I believe it clearly stated that in the rebuild.
The rebuild, if we'll reiterate, complete rebuild, comma, replaster, comma, and paint of damaged wall. If my understanding of the English language is correct, I'm pretty sure that the rebuild, replaster, and paint of is attached to a damaged wall, am I correct?
Possibly, but I believe
But
that.
maybe that
covers
question should have been directed to the contractor who did. Because as the previous owner of the home, he's just telling you, I had it fixed. Now, to interpret the invoice, the best witness would be the witness who prepared the invoice and did the work. They would know what was done.
I wanted to have the actual construction people, but the defense didn't want to have a witness of construction.
Because this
So I
witness
comply.
might not know more than what's written and his
But it's-
interpretation of what's written.
It's also,
called the witness all on me.
it's also,
We just never got people to do.
it's also the responsibility of the homeowner to know what's being done in his house.
Yes, but that question is fine. What was done and but I mean, to interpret and extrapolate the wording of this, he didn't draft this document, so he's gonna tell you what he thinks, right? Whereas the person that drafted Escavación Rizzuto Sapuro, they would know exactly what they mean when they say rebuild walls.
Fine, fair enough. So, you do realize that, that the law is public and you can't just claim ignorance as a valid defense, right?
Where are you going with this, counsel?
You didn't answer the question.
Well,
That's not your job to question.
all right, could you re-ask it, please?
You do understand that the law is public and ignorance is not a valid defense?
That's right.
Okay. So, you are aware of Article 1728 of the Quebec Civil Code?
Why don't you read it out to us?
The article of the Civil Code
He's a regular witness, eh, Kevin? Does he really know what Article 1728? Maybe Mario would know?
Well, the law is public and we're supposed to know what
No,
they
I
are.
understand, but a
Okay,
regular
so-
person will not have the article. This is off record, okay, I'm just doing this because.
So my mother knows most of the code from Article 1 to 3,598.
1728 states that if the seller is aware could not have been unaware of a latent defect, that he is bound not only to restore the price but to pay all damages suffered by the buyer. Correct?
Well, that's correct, so I assume.
Okay. So if it states that if you were aware of the latent damages, that you should have informed them and you're still responsible for them, have you done so?
Objection, Your Honor, he did state that if he was aware of latent defects, we have not determined if it was latent defect or not.
Okay, but he's in cross, he's allowed to answer the question, and then you will argue. Just a question in cross.
What's the correct
All these distractions, like unnecessary distractions, have made me lose my train of thought, Your Honor. If counsel can
You
actually.
can reposition yourself.
Why didn't you disclose that the cracked foundation was not fixed yet?
I believe I disclosed that there were problems and they were all fixed, as they should be. Now, whether your clients went a little crazy down wherever and started screwing around with whatever foundations or whatever you want to call them, that's not my fault.
Did you, so basically you're saying that you did make them aware of whatever damages were there?
That is right.
Alright, no further questions.
One question. Please state to the court, what is your occupation once again?
Unemployed.
Your previous occupation?
Previous occupation, I was a real estate agent.
Did you have any expertise, experience, or have you ever held a hammer to build a wall?
No,
Thank you. No further questions.
Any other witnesses?
One more. I'd like to call Mr. Brent to the stand, please.
Your Honor, forgive me.
Thank you. Mr. Grant, you solemnly declare that your testimony is the truth and nothing but the truth, say I do?
You.
The witness?
Your Honor, I'd like to see what the witness has in his hand, please.
If there's personal notes, he doesn't have to disclose them.
Can I have those back, please?
No, these are Mrs. Grant's notes. Mr. Brent, once
So
again.
that after he read it,
I said it before.
but he still read it.
We're not in real court.
Mr. Brent, what's your household family income once again?
50,000 a year?
Perfect. Do you have any children?
No.
How many cars?
2.
2 cars. What kind of cars?
A Honda Civic and some sort of Toyota. I'm not really. My wife's car.
Oh, okay. So you just buy cars.
I don't really bother with those. Yeah.
No problem. No, it's okay. How much is the car worth?
The Civic is $18,000.
Yep.
And again, the Toyota. No.
Are you still paying for these cars?
No.
Fully paid. You have a mortgage on the house? Or pay cash?
Cash.
Pay everything cash. On a $50,000 house, you pay everything cash. Was there an inspection, prior to buying the house, was there an inspection done on the house?
Objection. It's a very big question. It's a very subjective question.
Prior to buying the house, did you have any inspection done on the house?
It's a yes or no question.
That's not subjective, suggestive. That's
Well,
suggestive.
it's a suggestive question, but I mean,
It's subjective. You're leading the witness.
you're asking.
I said, did you?
You're
Yes or no?
leading the
I
You're
said,
witness.
did you?
leading, he's your witness, you're not in cross.
You're not in cross, you're leading the witness.
Well, was there any inspection done?
That's the listen.
Still.
Or, what type of verification? What type of verification?
What type of verification was done prior to buying the house? On your end?
None.
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 None. Okay, no inspection done whatsoever. Perfect. Now, what kind of damages or claims did Mr. Eastman reveal to you prior to buying the house?
That there was cracks in the wall and that there was some sort of slight structural damage that had been repaired.
So he did reveal to you that there was damage.
Objection.
No, I'm just talking to myself, I'm not that
It
question.
doesn't matter, you can only say, right, that's.
I think that was-
What type of rectification was done on behalf of Mr. Eastman regarding his damages, if you recall? What did he say?
He had the wall fixed, he had the wall inspected and repaired.
Okay. Are you aware of what Mr. Eastman's job was? Okay.
factory worker.
Factory worker. How much were you making?
26, 27.
Objection, relevance.
Sustained.
Yeah.
Oh, where you going with it? Whether he's a brain surgeon or a
$50,000
factory
household
worker.
income, what do you think?
I have no more further questions. I'll say that.
More questions? You guys gotta get your closing arguments.
Let's go, see it.
I don't really have any questions for you, to be honest. What we'll do is, we'll talk a little bit about the case. What did you say you do for a living?
Factory worker,
And what did you say the income, net income was for your family?
50,000.
And how much was the house sold for?
Something around 40,000.
Objection, Your Honor, we're going to facts here, we've already done for an hour.
And you're establishing any new elements?
Yes.
Get to
Get
it.
to it.
Get to it.
Two judges, okay, cool. Contempt of court here, he thinks he's a judge.
That's not because I've been here.
That's why you made Mario the 21st century.
I'm surprised he didn't come in with the blue
Yeah,
ticks.
5 minutes.
Oh, no, I just lost my train of thought.
320,000.
$320,000. Now, with the damages that you have right now, are you capable of affording to pay for any damages at this moment in time?
No,
So is this the reason why you've waited until you had a response from the defendant?
absolutely. It is his responsibility.
No further questions.
One more question,
Yes.
Mr. Brent,
Yes.
once you notice damage, did you have an evaluation done on the wall?
Objection.
Sorry.
Subjective. It's a yes or no
He's in
question.
cross now.
Is this cross or is it still, he still has?
Oh, it's your witness.
It's his witness.
Prior to, well, once you noticed the damage to the wall in April, what did you do?
Call an inspector.
You called an inspector?
Well, we had it inspected.
Did you not claim that so where did this $48,000 claim come from?
Oh, sorry. Sorry, counselor. I didn't get much sleep last night.
Don't worry,
Could you re-ask me the question?
That's my job.
Where did this $48,000 claim come from?
The damage to the wall.
You made them up? No, where did they
No,
come
we did not. Would you like to see pictures of the wall?
from? Where did they come from?
From I don't know, the water, the damage that was already there that he had not fixed.
Once again, where did this $48,000?
How did you establish
how
that the
did you-
damage was $48,000?
We had it inspected.
Do you have proof of this inspection, of this $48,000 quote? Because, Your Honor, as
Your Honor,
defendants,
I'm
we
not-
have yet to receive any documentation concerning a $40,000 bill. No further questions.
Anything to add? Are you looking for something? or-
No, I'm just looking through my documents because I'm assuming that this is full of shit.
You know when you were saying contempt of court? You just crossed the line. You ready to plead? You ready to plead?
Yes, I am.
Okay.
Hold on, just walk over the bottom.
Witness time break.
Go ahead.
Your Honor, the plaintiff followed procedures and bought the house on their part in good faith. Upon taking ownership of the house, they have suffered much more than they should have at the expense of the defendant's negligence. Now, yes, the defendant claims that he had the construction company come and repair the walls, but it is still, he, the homeowner, his responsibility to make sure that the job is done adequately. Selectively repairing a portion of the damages and failing to make light of the unrepaired damages would be and should be an act of bad faith. The plaintiff, they just want the reimbursement the law protects them with. They have the right to enjoy their property that was claimed to be given to them in perfect condition as stated by the defendant. As for the defendant's counterclaim, it is completely unfounded in fact and in law. The plaintiff is suing the defendant as a previous homeowner and not as a real estate agent. The act corroborated with the fact that this is a civil suit, which is not public, and not a criminal suit, which is public, means that no harm can be done to his reputation. Additionally, any defamatory comments made are not necessarily libelous if they are in fact true, and to be honest, nothing was stated. There was no public report, there was nothing publicly stated by my clients stating anything about him and his malpractice. The defendant losing his job does not fall into the responsibility of whoever of my clients, the plaintiffs. So to conclude, the defendant cannot claim damages solely based on the grounds that the plaintiff is exercising a right that they have provided by law.
Thank you. Your Honor, the court. It just so happens that the Brents are claiming $50,000 from my client on the perfect occasion where they only make a $50,000 household income, which we all know that's a gross salary. So maybe they can't afford damages, so the easiest way out would be to get to my client, who they know was, I mean, his name is all over essentially on billboards. Furthermore, we have yet to receive any documentation concerning a quote, an estimate. Before the plaintiff's attorney was inquiring towards my client, what happened to their $7,000, where did it go? Well, we could say that the $48,000 is not documented. The damage could simply be $16,000, and they want to incorporate another $30,000 from my client's pocket, maybe to help their own personal income. Once again, no mitigating factors were done. Regarding our cross demand, plaintiff's attorney stated about a criminal case, no defamation, no problem. We live in society. In society, whether you like it or not, as soon as you have a blacklist or an asterisk, you will lose your job and you will lose your profession. My client holds a profession to his dear heart. He has worked at this job for many years. He has climbed his way up. We all know as a real estate agent, you work on commission. For him to claim $100,000 last year's income tax, he worked really hard. He lost his job. Real estate agency is all he has. If he wants to play anywhere else, they just simply have to look at his personal record. They'll see he was claimed for latent damages. Latent damages. It's a very funny word, because latent damages means that my client hid facts from the plaintiffs. Yet we have the Brents, both of them, David and Marie, who admitted that they were fully aware that there were damages on this wall 3 years ago. My client has no expertise in building a wall, does not even know how to hold a hammer. If you want, we can test it out. But he disclosed to the Brent that there was previous damage done to the wall. So there is no latent defect because the fact was not hidden. He solely believed that there was that it was repaired. If they want to claim their $40,000, I suggest first they get a documentation for $40,000, and secondly, go after Excavation, Resulu, and Seguro in order to claim that, because they didn't require law. Thank you very much.
By the way, documentation is with the inspection. Just throwing it out there. You don't get inspected and not have a quote.
Okay. What he's saying, okay, now the case is finished. What he's saying is, you're making the claim, you try to establish the claim, that you establish that there was a latent defect, and then you have to establish what it's going to cost to repair. So the motion mentioned $48,000, but he says there's no, like an entrepreneur that says to repair it, it's going to cost $48,000.
So that was the inspection done by the
So you're
RQ.
saying it's in the expert's report and the expert mentions it?
Yeah.
Okay. And on your end, your cross claim for $150,000, his rebuttal to that is that it's an indirect claim, and did you really establish that he lost his job? If he'd be such a hotshot real estate agent and he sold a home with a latent defect, is it sufficient to tarnish his reputation?
Of course it is.
Not to mention
Or
the
some
fact,
damages.
not to mention the fact that you can't, like, if
Who's gonna claim the most?
if I sue you for malpractice and we were in the suit, you can't turn around and sue us back saying that we defamed your character.
No.
It's-
Yeah, I mean,
you can't do
this
that.
is outside of court, and I had told you guys when you were preparing, the cross claim for loss of job is a very indirect claim, chances are you wouldn't get anything with that. Latent defect, Latent defect, I think it was, I mean, besides that, the latent defect, I think was pretty much even. Your arguments were good, your arguments were good. Was it a latent defect? You raised the issue that there was a problem, so he could have argued, then your buyer, your vendor, the buyers should have pushed it further, knowing that there was a problem. Should they have maybe have it inspected to make sure that the problem was properly repaired? Was he in bad faith? He says, there was a problem, I had it repaired. I mean, he's not, I mean, you hire a company, you pay for them, you assume that everything's done properly. So I think it's pretty well, I mean, it wouldn't have been an easy left or right case, you know, because the arguments are good on both ends.
I'm just saying, you don't want to deliberate.
No, but it was.
We're not gonna take it hard, who won?
Eh?
We're not gonna take it hard.
No,
Who won?
I mean, to me, it's not a winner and a loser, you
So, who
know?
won?
No, to us it is.
Who won?
There's no, I didn't do it in my group.
Is he guilty or not? That's what we want to know.
This is criminal, it's civil, there's no guilty party.
Is he owing money or not?
Right now, is there a damage? There is. Is it latent? I'm not so sure. I'm not so sure.
How?
That doesn't mean you won, because you're crossing with
I
BS.
don't care.
It's very good, guys.
Good job. Bye.
Very good job.